Good morning and welcome to Fresh Perspectives. My name is Gail, and I'm happy to say that my guest today is Kameron Brooks, an attorney and who specializes in in estate planning and some other things too, right?
Principally, it's estate planning, asset protection planning, tax planning, business succession planning, and trust and estate administration. That literally is 90% of what our firm does.
Mm-hmm. Yeah, you're not into going to trial for crimes, right?
No trial work at all.
I'll bet you like not having to do that. Is that why you picked
Absolutely.
this?
If I can stay out of court, I'm happy.
Oh, okay. Well, I wanted to say thank you for being so generous with your time, for coming on my television show and all of those workshops, those free workshops that you put on to help people.
Well, it's my pleasure. It's a pleasure to be here talking with you on these topics and also doing the workshops around the area, because there's a lot of information people need.
Oh,
and
right.
The workshops are a great way for people to come and learn some things.
Yeah, it's amazing how much those of us that are not in your line of work don't know. So, so the topic of the day is the stages of advanced estate planning. My first question is, why is planning important?
Okay, basically this is a review of what we talked about maybe the first session we had together. The reason we engage in estate planning at all is because of default laws. All of us have a plan that the state or the federal government has passed, whether we like it or not. Mm-hmm. And it's those default laws that we generally want to plan around. I'll give you a couple of examples, 3. First is a will. Mm-hmm. So if a person does not have a will, New York State has given you a will, and it may not be really what you want. For instance, if a case one of the first cases I was ever involved with, a farmer owned a farm, got married, then they had kids. Then he died unexpectedly, and he owned the farm. So his wife got half the farm, and their 3 little kids got the other half, mm-hmm. which led to another problem, because since they were little kids, they can't manage their own assets. So now we had to have 3 guardianships to manage the money for the kids. So that all this court involvement, when probably what the couple would have intended was that mom would inherit everything, mm-hmm. and then she would be responsible for the kids and then pass it on. But that was the default procedure. So people have wills to get around that default procedure, because most couples, have what we call sweetheart wills, mm-hmm. leave everything to each other. Mm-hmm. And that takes care of the default law and gets it out of the way. Another area is healthcare proxies. Of course, we have healthcare proxies to appoint someone to make our healthcare decisions in the event that we cannot. So if we don't have one of those, there's a default law, and it's not too bad at the first level, because the first level of people that can make decisions for you would be a spouse. Mm-hmm. And that's 99.9% of the time the person you would pick. But if you get down to the second level, it's children, mm-hmm. plural. So that's okay if you have one child, but if you have more than one child, and if they have differing views on how they think mom or dad should be cared for, now you've got 2 people competing to make those decisions, and what's going to wind up is you're going to wind up in court in a guardianship proceeding. The last thing, and one I see is I think potentially the most horrific, is not having a power of attorney. So reason we do power of attorneys and insist to our clients that they should have them is the statutory alternative is called an adult guardianship proceeding. And it's what I less than affectionately call a Holy Rocky Mountain horror show.
Oh.
With an adult guardianship, it is an adversarial proceeding, mm-hmm. which means somebody has to bring an action against the alleged incompetent person and saying, I allege that you're incompetent. And this has to be done in the Supreme Court. So the petitioner needs an attorney. So then once the action gets started, the judge has to appoint an attorney for the, I'll call victim, the alleged incompetent person. So you have attorney number 2. And then, under the statute, the court also appoints a court evaluator, usually an attorney, so that's attorney number 3. And who pays for all those? The alleged incompetent person.
Right.
Sometimes the alleged incompetent person doesn't think they're incompetent. And everybody else around them knows they are, but they just don't think so. So they're mad that someone is bringing an action against them. The whole procedure takes about 3 months, costs somewhere around $10,000.
Oh my gosh.
And usually results in some petitioner being appointed guardian. All right, so now the person is a guardian of the incompetent person. They have control over the person, which means they can make that person go live somewhere. More importantly, they have control over the finances. So now they can actually take control, start paying bills, but you have a 3-month lag there before they're appointed. And then once they're appointed, they have to account to the court every year a guardianship accounting, which you have to pay the guardianship clerk to review. So the court stays involved with this literally forever. So to get away from that, you have a power of attorney. The power of attorney agent can take over immediately. Do not have to go to court. Can just start paying bills immediately. That's the beauty of it. So those are the 3 areas I think that are most important, is having a will to avoid the default rules, having a healthcare proxy so you can choose who you want to make these decisions for you, and third, having a power of attorney agent who can jump in and start handling everything without going to court. There's no expense involved in it. It really works. So that's why we need to plan.
Oh, yeah.
Generally.
Yeah. Well, you do kind of a package deal anyway, don't you? Where when somebody comes to you to have their will made, where you do all 3 of those things, the will and the power of attorney and the healthcare proxy. So, yeah, it makes a lot of sense to have all that taken care of.
Yeah, what we need, Gail, is as adults, we need to have documents in place, powers in place for things that may affect us during our lifetime and then after death. So that's where the will or the trust, whatever you have, would take care of things after death. But in the meantime, the healthcare proxy and the power of attorney are for lifetime activity.
Yeah. I remember when my mother had the stroke, she wasn't going to be able to be taking care of things for herself. I remember having a terrible time with her, the people that she had a charge card with. You know, they wouldn't, I basically wanted to pay, after she had the stroke, I wanted to pay off the $6,000 or whatever it was that she owed and get it taken care of, you know, so it didn't run up a bunch of interest. And then they go, well, we have to have a copy of the power of attorney first before we can even talk to you about it. We can't do anything right now. So I went to the library where I could fax it to them, and then they wanted to. I guess they probably wanted to make another couple months worth of interest off of her. You know, they were they claimed they hadn't gotten the fax, and so then I kind of just mailed them a hard copy of it, you know, and then finally I was able to get that under control. But they still sent me a bill for a small amount of money after I had already even closed down the account. And I remember calling them up, and the girl at the company, the one that answered the phone, I remember screaming at her because I was so angry. I said, you better get this taken care of today, or I'm going to call the state attorney general's office or something, you know. And it's like, so that was finally the end of it. But they didn't really want to let her go. I figured, well, you know, now she's probably not going to be going shopping or anything anymore. We're just going to, at this point in time, we're just going to her money's just going to go towards what she absolutely has to
Right.
have. You
Yeah,
know?
your experience with your mom is very typical these days. If you backed up 30, 35 years ago, you could have called the credit card company and gotten all the information, arranged for everything, gotten it done without a power of attorney. That was very likely. Today, nobody is talking to anybody except the account holder unless you have a power of attorney. That's why it's becoming increasingly important to have that today, even for young folks.
Oh yeah, and then even with those HIPAA forms, you can't talk to
Yeah.
to your mother's health insurance company about her until she signs a HIPAA form.
Yeah, yeah. I think my personal belief is anybody who's over the age of 18 should at least have a power of attorney and a healthcare proxy with a HIPAA release in it. When my boys turned 18, they both gave me a power of attorney for them.
Oh yeah.
And one of the frustrating things is one son was in college and I was going to pay his tuition bill. So I called the college, said, how much is the bill? And I said, we can't tell you. He's 18, this is his account, I can't tell you. And I said, well, you do realize I'm paying it. And I have a check here. I can't tell you how much it is. So tell you what, I'll email you his power of attorney and then you can talk with me. So that, you need those. I think a younger person, maybe age 18, 19, 20, 21, you know, they don't have much. I mean, my kids had a car, used car, and a couple $100 in the bank and some personal property. All right, they didn't really need a will. If something happened to them, it would be an easy thing to deal with. But the power of attorney and the healthcare proxy, I think is very important because if they became disabled in a car crash or something, then the power of attorney becomes extremely important and the healthcare proxy, extremely important.
Right, right.
So everybody over age 18, because once you're 18, you're an adult and all the adult laws apply to you. Whether you like it or not.
Yeah, yeah, that was the next question, actually. Who should plan? Yeah, you know, which makes me think of something, and this has to do with life insurance.
Okay.
And I remember reading a book by that Susie Orman one time, and, you know, she's that famous financial planner, and she said something about, you know, she goes, I don't really care if people have life insurance or not. She goes, that was something that was originally invented for people who, the first 10 years of their adult life, because they hadn't had time to save up money to pay for a funeral. You know, was how life insurance originally got invented, and but you know, you know, that's another story though too. But so, do you have any more to say about who should plan? I mean, that's everybody 18 and older.
Right. Yes, at
right?
18 you're an adult, you should do something.
Right.
Power of attorney, healthcare proxy, probably a minimum. But as we age, things change. We begin to accumulate some things. You know, we have real estate, cars, bank accounts, investment accounts, things like that. So the planning then becomes a little more complicated because now we have more things to pass on. So, and also, this is a big area where a lot of couples are at risk. Let's say you have a couple that are maybe they're in their late 20s, early 30s, or in 40s. So they're married, they're working, they're accumulating some things, and now they have kids. They have children. One of the risks is what happens if the parents pass.
Oh yeah.
And leave kids. Now there was a case I remembered years ago. Some people told me about a couple over in the arcade area that left their kids, 9-year-old and 9 and 11-year-old, left them with a babysitter, went out to dinner, never came home. They were involved in a car accident, both of them were killed.
Oh, yeah.
And they left an 11 and 9-year-old, no estate plan at all, nothing. Now they would have a house, they'd have retirement accounts at work, life insurances, those are typical things. So people at that age group don't think I need to plan because I don't really have anything. And they're thinking about what's in their checkbook. But you think about the life insurance and the 401k at work, maybe some group life insurance at work that is payable what would, in that case, would wind up payable to their estate, and that would go to these little kids. No trusts. No trust to age 25 or 30. The kids have to have guardianship accounts again, and at age 18, they have to be given the money, whether they're responsible or not.
So you should, young people who have children should have some sort of legal document that says what to do with the children. You know, like probably everybody should have somebody picked out and have a legal document about it that like a relative, if you want a friend or a relative, and you know that those people are willing to take the children if something that happens to you.
That would be guardians. You appoint guardians in the will.
So,
now, when you appoint guardians in a will, you better talk with them ahead of time, because any fiduciary you appoint with guardian, trustee, executors, they don't have to serve. So
they can
bow out
turn
and say,
you down.
Yeah, they can say no.
Okay.
So it's better to find out ahead of time if they're willing to do the job. So if you have children under 18, they need a legal guardian, and it's better if you appoint that in your will with people you know that will do the job. And then secondly, leaving things in trust for these kids, maybe to age, I think certainly to age 25, if not beyond. And then appointing trustees, which could be the same people, but you appoint a trustee to manage those accounts until the proper age for those kids. And then of course you appoint executors to administer the estate, which is then going to pour into the trust.
Yeah, I think most people would rather have the guardians be a relative or a friend rather than having the kids become orphans, you know, and you know.
And there's a default law on that too, because if nobody steps up to the plate, the Department of Social Services has the obligation of becoming the guardian for those kids. Now, the state, the county Department of Social Services doesn't want to do that. That's not their primary purpose in life. Much better to have family members taking care of family members.
Right, right. That would be the best thing. So, okay, what should an 18-year-old consider in estate planning? You sort of already answered that. It says default inheritance laws might be fine for younger adults who are not married and do not have much. You said you had a couple of cases of 18-year-olds with trusts that you wanted to mention?
Most 18-year-olds, 18 to 21-year-olds like that don't have much. I've had two cases where I had 18-year-olds that were multimillionaires.
Oh gosh, wow.
And it's because of personal injury lawsuits. They were involved in car accidents. They got a large award, a structured settlement award, and when they turn 18, they're an adult. They get the money. So we devised a plan with their attorney and their parents to have two trusts, two irrevocable trusts. We had a life insurance trust because they have a federally taxable estate, so we needed insurance to pay for estate taxes if that were to happen. And then another trust that we made irrevocable so that the money would be handled by the parents until the child became 30.
Oh.
And we did that as a defensive maneuver so that the child was not a target for friends that in need.
Oh, yeah.
And everybody's going to know at age 18, you've got a lot of money. And all of a sudden you get a lot of friends and they have needs and they want to borrow money, never can pay it back. And it was just much easier for the kid to say, I don't have it. It's in trust.
Right,
So,
right, yeah.
But those are
especially if the kids were multimillionaires, people would be looking to try to figure out a way to take advantage of them.
Yeah.
And I as hard as it might sound to some people, I've heard that millions of dollars can go fast.
Oh, yes.
You know, if there's other people dipping into your pocket, you know, and a lot of people don't pay back money they've borrowed.
Of course. The insurance industry, the American Bar Association, a lot of different places keep doing studies about people that inherit large sums of money or hit the lottery and they have $5 million. In so many cases, in 5 years, it's gone. Extravagant lifestyle, lots of parties, lots of friends, And the thought is, I guess, if you inherit that large sum of money all at once, it's never going to run out. That's the thought. But it does run out. So there are a lot of people that are that just squander it, and 5 years later it's gone. So especially with younger people, you want to protect them from doing that and from being targets.
Yeah, because younger adults tend to not be really smart about things like that. You know, you're not as mature.
Oh, yeah.
You haven't been around the block a bunch of times yet, and you know, experienced enough to know better.
Yeah.
So, so young adults, probably that's the most dangerous times of their lives for them.
I think you're right.
You know, because they don't necessarily, they're adults, but they haven't had the experiences to show them what kind of trouble
they're
they
adults
get
because the law says at age 18 you're an adult. That's the only reason they're an adult. But they don't have very many life experiences.
Because they, you know, research has shown that people's brains aren't completely developed until they're way up in their 20s somewhere. So yeah, it's definitely a good idea that not to make them bait for so-called friends.
Exactly.
You know.
And the idea of a, say, a married couple providing for trust for their kids in the event if something happens to both married couple, not only does it keep the money away from the kids for them to squander, but it also a trust provides creditor protection for those kids. So let's say we have a 19-year-old trust beneficiary that has an accident with a car and causes a big liability. The trust fund can't be used for that.
Can't be accessed.
Right. So there's creditor protection for it. It's a very smart thing to do. So in this progression of planning, you know, the young 18 to 20-year-old that doesn't have anything, maybe no will's okay. But when you get into married life, or even if you're a single person with kids, you have to think about guardians and trust for the kids to age whatever. And then beyond that, we go down to the next kind of group, would be as you people approach retirement age.
Right. When does it seem appropriate to plan differently, say a little bit more?
Well, it all depends upon the individual, quite frankly. I mean, there's not many 18-year-olds that have a very sophisticated estate plan because they're multimillionaires. That's the exception. But most people, when they're in their 50s and 60s, now they're looking at life and saying, I've used up more life than I have left. So you tend to be a little more conscious about the end of life being out there for you somewhere. And also, at that point, you look around and see what you've collected over the years, the bank accounts, the investment accounts, the annuities and life insurance and retirement accounts, other property, house in Florida, things like that. You kind of amass a small family fortune. And now other risks come into play, like what if dementia happens? What if nursing home happens? You know, do I want to plan now to avoid having to having to spend all my money down? You know, what do I want to protect to go to the family after I pass? Just the level of planning becomes more complicated at people at that age group, just simply because of the laws that they are expected to face more sooner than later, and what they have to protect. Now, a person who has nothing probably doesn't have to worry about much because you have nothing. But more people have more things, so they need to plan accordingly and make sure that they think about all the possibilities that can happen and then think about what risks they're willing to accept or not. I've met with clients who are not concerned about long-term care in a nursing home. They're just not concerned about it. They don't have children. Our money's ours, we'll use it for our stay in a nursing home if we have to. Other people have said, I've helped my kids enough. If they get something from me when I die, fine. If they don't, fine. I don't care. That's a conscious decision. Too many people have not thought about it, have not made that conscious decision, and then maybe wind up having a stroke into the nursing home, and then say, oh my gosh, I'm going to lose everything. What can we do? And at that point, it's crisis mode. Yeah. And there's less you can do, and it costs 3 times as much to do it.
Oh, yeah. Okay, so basically, you want to have something legally taken care of at least 5 years before that happens.
Yes, that's important if Medicaid asset protection planning is important. So if the thought is, and when I get near 80 years old, I may go to a nursing home and I want to plan to save some of my assets from that spend down, we need 5 years, 60 months right now to do that. It's better to plan in advance against something that may happen to you and have that plan in place and get the clock ticking than it is to hope I'm not going to go to a nursing home and then wind up there and then scramble with a crisis plan. And the other thing, Gail, too, is that we talked about power of attorneys.
Right.
I like to use the analogy of the Sears product model.
Oh,
Remember years ago, Sears had their label products, good, better, and best. Well, a power of attorney, any power of attorney is good. It's better than nothing. But there's a better power of attorney that gives you some extra powers, some extra abilities, and then there's the best. Now, we've worked hard to make ours in the best category because we deal so much in this area that we see a lot of things.
Right.
So we have added 23 extra powers to our power of attorney, a lot of them to accommodate estate planning issues and many of them to accommodate crisis Medicaid planning. Because if you're doing a crisis Medicaid plan, you need the power, the agent under the power of attorney needs the power to make a big gift. And a standard power of attorney doesn't give the agent the power to make any gifts.
Oh, really?
Well, of more than $500. The statutory power is $500. That's it.
Oh, okay.
So you need to expand that to be able to do a good crisis plan.
Right. Okay. What about people at retirement age?
Yeah, well, that's, the people under 50 to 60s, I think retirement age, I still look at it as being 65. There are people that retire earlier, people that retire later, but generally in mid-60s, it's a good time to think about your whole entire plan because when you retire, you're thinking about a lot of things. Okay, I'm not going to work anymore. I'm dependent upon retirement income. And what do I do with my time? Which all my clients don't have a problem with that. They fill their time up with all sorts of things. But you're thinking about a major life change, really. We're not working anymore, we're doing something else. That's a good time to really think about your plan and to say, what am I facing down the road? What may happen? What do I want to guard against? And that sort of thing. So some of the things we were just talking about, like especially with Medicaid planning.
Yeah, what do you recommend, like when it comes to people retiring? Now, a lot of people retire at age 62 now instead of waiting till full retirement age at 66. Sometimes it's because of, a situation, maybe they aren't able, for some reason they aren't able to just really work anymore.
Right.
So they sign up early, but then you hear stories about people getting a lot less Social Security if they take it early. Do you have anything? Do you have any opinion about that?
Not really. The advice to anybody who thinks about taking Social Security at 62 is to ask themselves the question: how much am I going to work beyond age 62 and earn? Because there's a limit. I don't know what the limit is now, it's around $15,000 a year. If you earn more than $15,000 a year, then after that you lose $1 for every 2 of your Social Security benefit.
Oh.
So that is a problem. Now I have a lot of clients that retired early, 60, that have such good retirement income, they're never going to work. They're going to volunteer, but they're never going to work. So they take their Social Security at age 62, just because they know they're not going to work. Myself, I worked up to age 66, and I'm still working full time.
Yeah,
but I waited till 66 to take Social Security because I couldn't do it at age 62 because I made too much money.
You were earning too much money. Yeah.
So it's really an individual choice, but you have to look at it and say, how much money can I earn part-time working at age 63 and 64 that I can stay underneath the limit?
Yeah, some people, I just wondered, some people quit working in their early 60s because their parents became disabled and they quit working to take care of them. And so they need a little bit of income at least, so. Although now I'm hearing that they're trying to make things so that people are taken care of for the amount of time they're putting in taking care of their parents.
Yeah, so goes back to that community Medicaid that we talked about the last time I was here. There is a program where a family member can be hired, can be paid to take care of another family member, whether it's a child for a parent or something like that.
So that's something that people can look into.
Yeah, they can definitely look into it.
If they find themselves in that situation, yeah.
Yeah, there's a program that permits that.
Okay. Who do you appoint as agents, like executors, trustees, and power of attorneys?
That's a good question. Most people appoint family members. It's kind of common. If a couple comes in, they're going to appoint each other first, and then some or all of their children. But it can be anybody. It can be anybody that is qualified for the job and you trust. Doesn't have to be family members. The executor, the trustees. Some people choose bank or investment company trust companies or trust departments. The nice thing about bank trust departments or investment company trust departments is they don't go away. They can't die. They're always going to be there. And they have professional management. So I would say if a client has a larger portfolio to manage for somebody in a trust, that maybe the trust company would be a good pick, or perhaps a trust company and a family member as co-trustees.
Oh, yeah.
So the family member has the personal sense of the family needs and whatnot, and the corporate trustee has the expertise in investment and accounting and things like that. But I think most times people choose family members just because they're the closest, and a person does not have to be a accountant to be a trustee. It just has to be someone who's willing to seek advice and take it. That's really it. Now, power attorneys and healthcare proxies is a little bit different because you can't have a corporate trustee, be a power attorney agent. They're not going to do it, period. You're almost always going to have a relative or a close friend. I've had several clients that had no family at all, and they appointed a close friend, someone they trusted. But in most cases, people have family, they have kids, or nieces or nephews that are close to them, and those are the people that you tend to look at to appoint to these positions.
Yeah, okay. What about blended families?
Well, that's another kettle of fish, and it's a big kettle. There are more blended families out there than ever.
Probably because the divorce
rate
has
it's
gotten to be more than ever, you know?
And so, we've seen blended families for years, but it just seems like there's more of them now.
Yeah.
Now, interestingly, in the planning world, that presents its whole different set of circumstances and challenges, because this is where the default laws really works against a family, a blended family. If you have two people that have kids from prior marriages and they get married and they have no wills, someone's going to get disadvantaged just because of the way the laws work. So it almost by necessity, a blended family couple needs to have good planning. And it may very well include a prenuptial agreement, but probably a postnuptial agreement because they're probably already married. And because I still think most people think, well, what I brought into the marriage when I leave this world, I want it to go back to my kids. And what you brought in the marriage, your kids get that. The default laws will not accommodate that. You've got to really do some things, maybe a postnuptial agreement, and then some estate planning documents, whether it's wills or trusts, and some waivers of a right of elections and things like that, because there are default laws that give spouses a lot of options. And so, for instance, if I'm in a second marriage and I have my will that says I leave everything to my boys, and I die before my second wife, she can elect against my will and take half of it. Just for the asking.
Oh, yeah.
No argument, just for the asking. So you would want, in that situation, you'd want her to waive her right of election against my will, and vice versa. So there's a lot of things that need to be planned with a blended family.
Oh, yeah. I knew this one family the husband and wife had both been divorced, and they married each other. They met each other and fell in love and got married. And at the end of their life, when they were in their 80s, the husband was 10 years past having had a stroke, and he was going downhill really fast. And the wife had been diagnosed with lung cancer, and she was going to die in the near future, too. It looked like they were both going to die in the coming year. So they redid their wills and everything, I remember. And the wife was actually the one who had come from a well-to-do family, so she was the one who had most of the money. And the husband owned this house and had some money. And what they wound up doing was each of them willed in their final wills. They each willed what was theirs to their own children. Right. So they got a big chunk of money. Her natural children did, and the husband had 2 children, and the son got the house, and the daughter got enough money that was worth the amount of the house, and any money that was going to be left over beyond that would be divided between the 2 of them, and that was how they settled it. Although I think the husband's son felt a little bit disappointed that he wasn't getting part of his stepmother's money, but you know, that's the way it went, you know.
Yeah. Now, the problem in that case is by using wills, unless there were waivers, if the husband died first, the wife would have the right of election against his estate. If wife dies first, husband has the right of election against her estate. So when they did their wills, they probably had waivers of the right of election too, so they could guarantee that what was theirs would go to their kids.
Probably.
Now, there's another wrinkle on this too, Gail, because I've had a similar situation here a couple of years ago, very similar to what you're talking about. Second marriage, wife had assets, husband had a house on the lake here in Chautauqua Lake, and he went to the nursing home.
Oh,
Now, they had a prenuptial agreement. What is his was his, what is hers was hers. They thought they had everything in order. But Medicaid rules don't care about prenuptial agreements. If you're married, your
stuff is mixed in together. Yeah.
So it worked out okay because he was in a nursing home maybe for 6 months or so when he passed, and his house was enough to pay, when they sold it, was enough to pay off the nursing home. So the wife's money never got touched. But the risk was that if he had been in the nursing home long enough, and if the sale proceeds of his house were not enough to cover the nursing home bill, then he still wouldn't qualify for Medicaid because of her assets. Now, she could file a spousal refusal that she wouldn't contribute. He would still get Medicaid, but then the county sues her for contribution. So that's something, especially with an older couple, blended families, second, third marriage, you have to worry about the Medicaid issues.
Oh, yeah.
Because they crop up.
Yeah. Well, in this particular, with this particular couple, the wife passed away first, and it was only another 2 or 3 months when the husband passed. So they actually passed quite close to each, one shortly after the other. So it wasn't too much time, actually. But
it worked out all right.
It worked out okay.
That's good.
So, okay, what about estate taxes?
Real good question. Everybody's going to love this answer. 99.8% of us are not going to pay federal estate tax. That's a lot of people. The estate tax exclusion amount, is what we call it for federal purposes, is $11.4 million per person. That means a couple can pass $22.8 million to anybody they want in the world, if it's done right, pay no federal tax at all. Now, the state is not quite as generous yet. In the state, the limit right now is 5.49 million per person. So that's still about $11 million that people are not going to, up to $11 million you pay no state tax. No state tax, no federal tax. So that's real good news on the estate tax front.
Oh, okay. So does that mean that the children of the people, when they pass, do not have to pay income tax on that, or
well, an inheritance per se is not income taxable. It's estate taxable. So yeah, children are not going to pay any, or the estate is not going to pay any estate tax. If there are items of income that come to the kids from the estate, yeah, that's income taxable. Sure, it always is. One of the things that's always taxable is retirement accounts. A retirement account is included in your estate for estate tax purposes. But when the money comes out of the retirement account to whoever it comes out to is always income taxable. So there's a component of income tax usually in every estate. Most of the time it's not a big item. So most of what people inherit is going to be tax-free.
Okay. So as far as the retirement accounts, can that be passed to an heir without them having to pay tax before they get to be 70 and a half?
Actually, no. The rule on retirement accounts is if I have an IRA and you are my beneficiary, I die, it now becomes an inherited IRA for you. You cannot mix it with your own IRA. It has to stand alone. And you have to take minimum distributions each year based on your life, even if you're 5 years old.
Oh, really?
You cannot defer it to age 70 and a half because...
Oh, really? It's only ones that you opened up yourself.
Yeah. Well, unless, one caveat, if you're a spouse, if you inherit your spouse's, you can roll it over into yours.
Oh, okay.
You don't have to take it till you're 70 and a half. If you're a non-spouse, you have to keep it separate and you have to take a distribution each year based upon your age.
Can the heirs actually close out these accounts and take the money and put it somewhere else?
Oh, yeah.
Okay.
Yeah, the minimum distribution rules are just a required. You have to do this. You can take anything out of it you want, including the whole thing, if you're willing to pay the tax on it. Because you have to pay the income tax on it if you take it out. It's all income taxable.
Okay. Well, let's see. The questions are running into each other here. Do retirement accounts need any planning? But we were just...
Well, we talked about distributions, but talk about planning with retirement accounts. Yes, there's a big issue with that because we talked about wills, trust, things like that to pass to beneficiaries. Retirement accounts are different. They do not pass through your will. They do not pass through a trust. They pass by way of a beneficiary designation form. So anybody, and this is true for life insurance, annuities, and retirement accounts. You have a designated beneficiary on that account. Now, if you don't have a designated beneficiary, by default, it's your probate estate. And with a retirement account, that is what we call tax hell, because you have to take the money out pretty quickly when it comes to an estate. So people need to pay attention to the beneficiary designations on a retirement account, and it should match what their estate plan says. So the typical estate plan is, okay, everything spouses to each other, then to the children equally. And if a child predeceases, down to grandchildren. The beneficiary designations on all these other things, retirement accounts, annuities, and insurance accounts, may not match that program. They quite often you see, and I still see a lot of these beneficiary designations that say, once we get down to the 4 kids that you've named, if one of them passes away, we pay to 3. And you say, well, what about the children of this 4th one that died early? They don't get anything.
Oh.
This is what we call a per capita distribution, or I call the last man standing rule. You've got to be there alive when the person dies to collect. What we really want to see is something to guarantee that if a child does predecease and leaves grandchildren, that share goes to those grandkids and preferably into a trust for them.
Right, right.
So for a lot of these retirement account beneficiary designations, we're doing custom forms to make sure that things drop down to the correct beneficiaries, and if they're under whatever age for the trust, that it goes to the trustee to manage for the beneficiary.
Okay.
It's way too easy to disinherit grandchildren with beneficiary designation forms.
Yeah, I do know. I do know that. Well, in my family, for instance, my father's side of the family, I had two aunts. Their husbands were deceased, and these two elderly aunts, and they never had any children, my father's two oldest sisters. And the way their wills were made was basically, they were made out to any remaining sisters, and my mother, because my father had died, they had done something to where my mother got my father's share of the money, and then another sister and her husband that were both deceased. The will was made out so that their two daughters got her share of it. Yeah, I know it sounds kind of complicated, but their wills were made out to make sure that all of the right people got the right money.
Yeah, typically I think all attorneys that engage in estate planning and do wills, we usually use a term called per stirpes.
Oh yeah.
So you say to my children per stirpes, and that guarantees that if a child predeceases, that child's children will get the money.
Oh, okay, that's what per stirpes means.
It's the opposite of per capita.
Okay, so it just means that if the child dies and has children, the child's children will get the money then.
Yeah,
so
exactly.
That's basically how this will, with these two aunts, the wills of these two aunts of mine, how that went.
You know, this is a good segue into something else I just thought of. I've had a number of clients that were never married, never had children. So they tend to leave things to their siblings who are that same age group.
Right, right.
So I've had a client where we did an asset protection trust for her, and she wanted to leave everything to her siblings. And I'm thinking, well, they're about her same age. As they all age out, and I asked her, what happens if one of them goes to a nursing home? Do you want their inheritance? And she goes, no, I want to protect that. So in that case, and I've done this several times, we don't leave the money to the siblings. We leave it in trust for the siblings and have a provision in it that if they're in the nursing home, then they don't get anything out of the trust. It drops down to their kids.
Okay.
So in this one case, my client died, and she left 4 siblings. 2 of them are in a nursing home. So those sub-trusts don't pay anything for those 2, and that'll go down to their kids.
Oh, yeah.
So it's a way of, let's identify what we have and what we want to protect, and where we want things to go.
Right.
And let's get it into the plan initially so that we know what's going to happen when death happens, or disability, or nursing home, or what have you happens. Right,
right. There are options available on financial institutions forms that vary widely.
Yeah, we're seeing that more. More financial institutions, when you have, for instance, a retirement account, they may have, where you set down your beneficiaries, little boxes you can check, per capita, per stirpes, whatever, and that's good. Now, not all of them are doing this, and I still have a problem with even a per stirpes designation on the financial institutions form, because if that per stirpes designation means that the child share goes to grandchildren, how old are they? You know, you have to look and say, how big's the account? How much is, would it possibly that might be inherited by those grandkids? If it's a small amount, we don't worry about it too much, but what if it's 100,000? What if it's 200,000? Now you have an inherited IRA owned by a 15-year-old that, number one, can't manage it because they're underage. Now you have to have a guardianship, and we don't want to do that. So having that drop into a trust, a sub-trust for that grandchild, is a lot better way to handle it.
Yeah, okay, sometimes the people, the crew here, hand me notes of things they would like to know.
Okay.
And this question is there a way to protect people who may not be legally connected to a designee? And the examples they want to know about is same-sex couples, unadopted and adopted children, and foster children.
Sure.
Of course, you know, I don't think that foster children inherit anything from foster parents, do they?
Not statutorily, not under the default laws. So if you say in your estate plan, to my children per stirpes, then that means children who are born or adopted of those children. And we have a number of clients, blended marriages and things like that, where, or blended marriage at the children's level. So we have a child that has 2 naturally born children and a stepchild that my clients treat just like a grandkid. And they say, we want to include that person. In that case, you've got to specifically name them.
Okay.
So we either do it definitionally in the document, children or grandchildren also mean this person, or we say this person per stirpes to include stepchild number 1 or whatever it is. So stepchildren, foster kids, anybody. I've had clients that have left money to foreign exchange students.
Oh, really?
Yeah.
Wow.
Who lived with them for a year, and now we're back in the States, married and living somewhere. They have a lot of contact with them, and they wanted to leave or something.
Oh.
You specifically mentioned that. Now, getting to the issue of same-sex marriages, same-sex marriages have all the protection and all the legal rights and responsibilities as any married couple in New York or under federal law. So the right of election against a will applies to a same-sex spouse. So if you have an estate plan that says I leave my estate to my spouse, if that is a same-sex spouse, they get it. That there's more protections for a married couple, however they're matched up, than there are for couples that just live together. There are a lot of couples that have lived together for 30 years, have kids, everything, and they have none of those protections. So,
well, okay, so if you're going to live together not being married, and you want to leave stuff to that companion, they absolutely have to be named in the will.
Absolutely.
So, but probably foster children, usually that's kind of like it's a kind of work the people are doing by taking in foster children. Sometimes they'll adopt the children.
Sometimes.
But,
sometimes, Gail, someone will have well, I'll give you a good example in my family. We have a foster sister, lived with us for 1 year. Now, we had someone graduating from high school every year for 7 years. There was a gap year that the natural born kids missed between my first older sister and my second older sister. And that's where the foster daughters came in.
Oh, okay.
So my parents started treating her just like any other, the rest of us. Helped her go to college, and she's been a member of the family ever since. So when my parents passed and they left their estate plan, it was we're dividing everything 7 ways. So that's a case where a one year residency foster child became a member of our family.
And still is today.
Still is today.
Yeah. Well, of course, it's not going to be it's not going to be that way every time.
No.
You know, I'm sure that a lot of people that take in foster children do it so often that there would be no way that they could.
Well, I think most foster parent-foster child relationships are temporary.
Right.
And then the foster child moves on, and they probably lose contact with them.
Right.
Yeah, in my family, that was just an oddball thing that happened.
Yeah. Oh, yeah. Yeah, because I've known various different people, you know, that had kept foster children, and I just always saw it as a type of work that people did. Of course, they'd have to be really caring people to do it. So,
Yeah.
but anyway, if they wanted to leave money to a foster child, the child would have to be named in the will.
Exactly, yeah.
So,
Anybody who's not a blood relative, you need to specifically include them in the documents. One other thing I want to touch on here before I forget, Gail,
Okay.
is getting back to the financial institutions and the beneficiary
Right.
designations. A lot of financial institutions now offer what's called a TOD or POD designation on any account. That's transfer on death or pay on death
oh, is that
accounts.
what those initials
That's what they
mean?
stand for. The problem I have with those is that you have to really read the TOD agreement to see what happens if you name multiple beneficiaries, what happens if one of them dies. And there's one company that is represented in the area, and I know that they're represented as well, and we were talking about using a TOD, and I said, I'll bet you anything it's per capita. And he sent me a copy of it, we read it together, I said, right there it is. If you name contingent beneficiaries, we will pay those that survive. That's per capita. And he said, oh yeah, I didn't realize that. Well, that is exactly the opposite of what the client's estate plan
Oh,
says.
okay.
So you have to be careful about it. Now, I like TODs when they're payable to trusts because I'm in control of the trust. The client's in control of the trust. They change the beneficiaries of the trust all the time. Now we have that account being paid directly to the trust. That I think is good. But you have to watch when you list the beneficiaries, because I think everybody assumes if I put my 2 kids down on this account, they will survive me. Betting odds are they will, but what if they don't? Have you just inadvertently disinherited grandkids? That's the big concern we have about that.
Oh, yeah.
And then even that, if you put a TOD to a young person, they can't manage the money until they're 18. And then once they're 18, you can't stop them from managing the money. They can do anything they want with it,
Right.
which might not be a smart thing at age 18.
Right, right. We all remember how we were when we were only 18 years old, don't we?
I like to say the story. If I was 18 and I had inherited maybe $50,000 back then, it would be red and it would say Corvette on all 4 corners of it.
Oh.
That's the first thing I would have bought. And I don't think that's changed much today.
Yeah,
For
yeah.
18-year-olds.
I don't think that maybe when you're really young like that, you haven't figured out how easy it would be to spend it all at once and not have any left to live on.
Yeah, well, you have no life experience to tell you otherwise.
Right, right. So,
It's an issue.
yeah. Well, we have run out of time, and I so appreciate you being willing to come on as often as you do
My
to
pleasure.
give advice. And how can people get a hold of you or find out about your workshops?
A good way to do that is with our website, brookslaw.biz, B-I-Z. And we post our workshops on our website so people can see. We also, when we're in an area and we're advertising for a workshop in the area, we're on Facebook. So people are likely to find it on Facebook, and they can sign up through our website for a workshop.
And their workshops are a lot of fun to go to. Not only do you get a lot of really good information, but they serve coffee and dessert at their workshops.
Yeah.
So, well, I guess we're going to sign off for now, and I'll see the rest of you in the viewing audience on the next episode of Fresh Perspectives in a couple of weeks.